Maine has a tenant protective lease termination framework that reflects the state's commitment to housing stability. The governing law is found in Maine Revised Statutes, Title 14, Chapter 710, the Forcible Entry and Detainer Statute, along with Title 14, Chapter 709, which covers general landlord-tenant provisions. If you manage rental property in Maine, the process requires patience and precision because Maine courts hold landlords to exacting standards. Let's start with no-cause termination. For tenancies at will, which is Maine's term for month-to-month arrangements, the landlord must provide at least 30 days written notice before the termination date. The notice must be a formal notice to quit and must comply with the requirements of Section 6002. It must be in writing, must identify the premises, must state the reason for the termination or state that no reason is required, and must specify the date the tenant must vacate. Here's something important about Maine. The state has recently enacted just cause eviction protections that significantly limit when a landlord can terminate a tenancy at will. Under recent amendments to Maine's landlord-tenant law, landlords in certain municipalities cannot terminate a tenancy at will without a legally recognized reason. Portland was the first Maine city to enact just cause protections, and the state legislature has been considering broader statewide measures. Landlords need to check whether their property is in a jurisdiction with just cause requirements before serving a no-cause notice. For fixed-term leases, the lease expires at the end of the agreed term. Maine does not require additional notice at the natural expiration unless the lease specifies otherwise. If the tenant remains after the lease expires and the landlord accepts rent, the tenancy converts to a tenancy at will subject to the 30-day notice requirement. For week-to-week tenancies, Maine requires 7 days' notice from either party. Now let's cover termination for cause. For non-payment of rent, Maine requires the landlord to provide a 7-day notice to quit. Under Section 6002, the landlord must serve written notice giving the tenant 7 days to pay the rent owed or vacate the premises. If the tenant pays the full amount within 7 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file a forcible entry and detainer action in district court. Maine's 7-day non-payment window is moderate compared to other states, shorter than the 14-day states, but longer than the 3-day states. The notice must clearly state the amount owed and must be served by an authorized method: personal delivery, leaving a copy at the tenant's last and usual place of abode, or sending by certified mail. Here's a critical aspect of Maine's non-payment process. The state has a right of redemption that tenants can exercise even after the court case has been filed. Under Maine law, the tenant can pay the full amount owed, including rent, court costs, and attorney's fees, at any time before the writ of possession is executed, and the eviction will be stopped. This right of redemption is powerful and can significantly extend the timeline for non-payment evictions. However, Maine does limit how many times the redemption right can be exercised. If the tenant has redeemed within the past 12 months, the court may deny a subsequent redemption request. For lease violations other than non-payment, Maine uses a 7-day notice to quit for most situations. The landlord must serve written notice specifying the violation and giving the tenant 7 days to vacate. For curable violations, the tenant should be given an opportunity to correct the problem within the 7-day period. If the tenant cures, the notice may be voided depending on the circumstances. If the tenant doesn't cure, the landlord can proceed with filing. Maine also recognizes a 30-day notice to quit for certain situations, particularly where the landlord is terminating a tenancy at will for reasons other than specific fault by the tenant. The distinction between the 7-day and 30-day notice depends on the grounds for termination, so landlords need to use the correct notice period for the specific situation. For serious violations, including criminal activity, drug offenses, and conduct that poses an immediate threat to safety, Maine provides an expedited pathway. Under Section 6002, the landlord can serve a 7-day notice to quit based on the violation and can request that the court schedule the hearing on a priority basis. For the most severe situations, including illegal drug activity that has been documented by law enforcement, the court can move quickly. Maine has specific statutory provisions addressing drug-related activity on rental property. Under Title 14, Section 6001, drug activity is explicitly listed as a ground for eviction. The landlord can serve notice and pursue eviction based on the drug activity without waiting for a criminal conviction. Documentation of the activity, such as police reports, witness statements, or law enforcement contacts, is sufficient to support the eviction filing. Maine also has a specific provision for situations where the tenant causes substantial damage to the property. Intentional or reckless damage that significantly impairs the value or habitability of the premises is grounds for a 7-day notice to quit. The landlord should document the damage thoroughly, including photographs and repair estimates, before filing. One important aspect of Maine's framework is the state's approach to seasonal and winter evictions. Maine courts have historically been reluctant to order evictions during the coldest winter months, particularly when the tenant has children or is elderly. While there's no formal statutory prohibition on winter evictions, judges have broad discretion to grant stays and continuances, and landlords should be prepared for potential delays if the eviction process coincides with harsh weather. The eviction process in Maine goes through the district court. The landlord files a forcible entry and detainer complaint after the notice to quit period has expired. The court schedules a hearing, typically within 2 to 4 weeks of filing. Maine's court process requires strict compliance with procedural requirements, and the notice to quit is scrutinized carefully. Any defect in the notice, wrong dates, insufficient specificity, improper service, can result in dismissal. At the hearing, the landlord presents evidence supporting the grounds for eviction, and the tenant has the opportunity to respond and raise defenses. Maine tenants can raise several defenses, including improper notice, the landlord's failure to maintain habitable conditions, retaliatory eviction, and discrimination. The habitability defense is particularly significant in Maine. If the tenant can demonstrate that the property has unresolved habitability defects that the landlord knew about, the court may deny the eviction or reduce the amount owed. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a period to appeal, typically within 10 days. If no appeal is filed, the landlord can request a writ of possession, and the sheriff carries out the physical eviction. The overall timeline from filing to removal is typically 4 to 8 weeks for uncontested cases. Contested cases, particularly those involving habitability defenses or redemption requests, can take considerably longer. Maine has a mediation program for landlord-tenant disputes that courts may encourage or require parties to participate in before proceeding to trial. Mediation can add time to the process, but often results in negotiated outcomes that are more satisfactory to both parties than a court judgment. Landlords should be open to mediation as a practical tool for resolving disputes without the cost and uncertainty of a full trial. On the tenant side, Maine provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Maine habitability video, the tenant can provide notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act, the tenant can pursue remedies including lease termination. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days notice following deployment or permanent change of station orders. Maine also has the Portsmouth Naval Shipyard nearby, making this provision relevant to military families in the state. Maine provides comprehensive early termination rights for victims of domestic violence, sexual assault, and stalking under Title 14, Section 6002A. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protection from abuse order, a police report, or a written statement from a qualified medical or mental health professional, a sexual assault counselor, or a domestic violence advocate. The tenant must provide at least 30 days' notice, and the landlord cannot charge early termination fees, withhold the security deposit solely because of the early termination, or report the early termination as negative rental history. Maine's domestic violence provision includes an important additional protection. The landlord cannot refuse to rent to a prospective tenant based on the fact that they previously terminated a lease due to domestic violence. This prevents victims from being penalized in future housing searches for exercising their legal rights. Maine also provides early termination rights for tenants who are at least 60 years of age and need to enter a residential care facility. The tenant must provide at least 30 days' notice, along with documentation supporting the need for relocation. Maine strictly prohibits self-help evictions. Under Title 14, Section 6014, a landlord who attempts to recover possession of a dwelling by force, threat, or by shutting off utilities or other essential services is liable for actual damages and may be liable for additional penalties, including attorney's fees. Courts in Maine take illegal lockouts seriously, and landlords who engage in self-help face both immediate financial liability and long-term damage to their credibility in any subsequent proceedings. Maine's anti-retaliation protections are strong. Under Title 14, Section 6001, a landlord cannot terminate a tenancy, increase rent, or decrease services in retaliation for a tenant making a good faith complaint about habitability to a government agency, exercising any legal right, or participating in a tenant's organization. The presumption of retaliation applies for 6 months after the tenant's protected activity, and any adverse action during that window shifts the burden to the landlord to prove a legitimate, non-retaliatory reason. One practical consideration for Maine landlords: the state's rental market is highly seasonal in certain areas. Coastal communities and resort towns see significant fluctuation in rental demand between summer and winter months. Landlords in these areas often use seasonal or short-term leases, which have different termination dynamics than standard year-round rentals. Understanding how Maine's landlord-tenant law applies to seasonal tenancies is important for landlords in tourist-driven markets. Maine requires landlords to return the security deposit within 30 days of the tenant vacating the property, or within 21 days if the tenancy was terminated due to a foreclosure. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit or provide the statement within the required period, they may forfeit the right to retain any portion and could be liable for double the amount wrongfully withheld, plus attorney's fees. Maine limits the security deposit to 2 months' rent. For the complete guide to Maine lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.